This being the trust, that this being the trust has got a special special status. That is probably here how do you recognize a person instead of a person? It is considered to be a idol. It is the idol which is holding the entire trust, right? Okay, and the manager will be the person who is looking after the affairs. It has got a special status. So now, in this case, now I've given you an example. In this case, whom do we make a party? If there is a kind of a sort of some legal damage, can you make
We can do it. We can file a case on a person who is managing the idol thing. So
okay? So assault. See, some sort of probably a
Administrative officer, sir.
hello. So it has got a special status, first point. And special status, pilgrimage, people are coming on their self. Okay, so whatsoever reason, they are coming on self. See, there are certain special entities where probably certain things cannot work out. So there are exceptions. So probably assault. Today we are trying to learn something about assault. One of the main objectives of the tort is to offer compensation to the victim in case of loss or injury suffered. The most common thing is in the form of money. As to reduce the harm caused by making the tortfeasor, or tortfeasor is a wrongdoer responsible for. See, in certain cases, there also can be a type of remedy in the form of an injunction. See, if someone trespasses, will be prosecuted. Notice. Okay. So, for example, if you own a piece of property and someone comes and tells you, don't selling it, you have to sell it only to me. Okay, so it is a kind of a threatening. Okay, so which probably you would not be willing to sell it to him. Right? Whatever the reason may be, you will like to leave the property, but you will not sell it to him because he threatened you. So the ego, some kind of a ego problem. So in practicality, you clearly state that some kind of a threat or attempt to do some hurt to another. See, it is a kind of a hurt. See, probably he would sell it to me only at this price. I will take it only on this price, or with some wrong intentions. Okay, So that is what an assault is, a threat or attempt to do hurt to another, and with an physical ability and intention to do some act. So so here, when someone is by any gesture or through any words, deeds, he is trying to assault, threaten you. How, what kind of threats can you get? In many cases, it happens that okay, you do that, I will do something. I will do what I'll do. I'll do like these words, or some persons also threaten in extort. They try to gain some money from you by some causing some threat. So it is criminal intimidating. Intimidating is a threat. So and they also try to create some reasonable danger to the society also. So it is restricted, it is prohibited under the public law, that is criminal law, crime. Okay, so certain times assault may be severe or a light threat also. But threat is clearly defined under the penal law as well as the civil law. Civil law probably includes a damage to your property. Any example anyone wants to give on assault? Suddenly you are in a crowd, someone tries to come slap you. Is it assault?
Yes, sir.
Yes, that is a physical attack. So that
Yes.
is the correct.
Next, anyone anything practically?
Anyone is threatening on call, phone.
Yeah. 507. When you receive a threat call, IPC 507, criminal through communication. Yes, it is prohibited. It is prohibited under penal law. Yes, next.
Using language that threatens or harms someone's reputation.
Reputation. So you give example of a reputation example.
Words are potent, and when you use language that threatens someone's reputation, you may also be charged with assault.
So damage to reputation, probably you can even have defamation, assault and defamation. Okay.
We can. So other example is when we go to a shop, if a product is broken, then we have to pay money. So that is also a reputation.
When we go to shop,
Real estate activities, most of the real estate activities
yeah, absolutely. Real estate activities, there will be more assault. Probably if it is connected with money, it will be extortion, taking, demanding some favor, something, extortion.
And unwanted
So,
touching,
sorry,
unwanted touching, attempted rape.
sorry, I didn't get you.
Unwanted touching, attempted rape.
Okay.
It doesn't come, I think so, sir, because it's a touching, right? It's not that reputation.
That is categorized under some different from. So pushing someone is also a kind of assault. See, in a heated argument, certain times, if if someone is asking, they try get out of the house or some sort of force. That is also within force, but some kind of, but where someone has a right and sorry, they have a right and they are intentionally invade. So within a class, if due to some personal reason I target some individual, then that is also kind of an assault. Okay, honoring, see, some kind of humiliation. Humiliation ante probably yeah, in my previous some students came to me and told me that I should also speak in Telugu because many people coming rural background and hence they wanted things to be in Telugu also. Okay, so humiliation. What is humiliation?
Sweetie, can you please mute yourself?
Humiliation.
Sir, assault done by the government officers to the sir.
See, okay, so you have a remedy in the form of injection also, as proof in civil cases is the preponderance of the evidence is much lower as in criminal cases. What is preponderance of evidence? The facts of which have to be proved beyond reasonable doubt is criminal law. Criminal law says that they should be the evidence should be such that it should be directly proving the guilt is the burden of proof in criminal. So the standard proof of burden of proof in civil cases is preponderance of the evidence. There should be some probability. Yes, probably it could have happened is sufficient for the civil case to bring the prima facie. That is the locus standi. Locus standi is probably you will use it in civil cases. That is, there should be some kind of litigation between some kind of cause of action, some kind of case in civil cases, preponderance of the evidence. But in criminal cases, there should be a direct relation which the evidence should clearly prove the guilt. So that is, they should be beyond reasonable doubt. There should not be any kind of reasons. That is, if there is some benefit of doubt to the accused, that evidence cannot be direct evidence. Usually nowadays what is happening, you are getting the probably the video footage, the digital evidences. Nowadays digital evidences are more where the guilt is coming before hand to the in the eyes as a admissible evidence. So, what kind of admissions is to be done? Again, you have to study in the Evidence Act. In Evidence Act, what you will understand? You will understand that the evidence, what evidence can be made admissible, what evidence cannot be made. It is non-admissible or probably improper evidence. Okay. So now, if someone tries to assault you, threaten you, then we need to file a case for the case in torts. Torts by asking for the threaten. That threaten is prohibited by the law, and probably you have caused some kind of damage. So, assault is a threat or an attempt to hurt another through some cause some legal damage to other. So, in an assault, there should be a actual contact is not necessary in any assault. So, that is, see, probably even standing and shouting yelling at you, you can also be assault. Then there is no physical. If you look at many people, probably only by words only they say many things. Okay, so through their excitement, so probably by their excitement, they cause many. Probably they even cause a public wrong, that is crime, and the intention as well as the act makes an assault. So there should be an intention. See, now in a house, probably there will be two. Probably in a family they have two children. The father tries to say something towards the son, threatening and the elder son, and probably benefiting the younger one. What do you think that there can be a tort?
No, sir.
Anyone, can you explain? In a family, there are two children. The elder one, father tries to assault and benefit the younger one. Can there be a tort, and why? If yes, how?
So that is not a criminal. That is not a criminal one. And also, if a person had injury, sometimes they can file.
You can file against your father.
Yes.
Yes. Explain.
Because nowadays, before in the schools, there is no harm happening for students. Okay. But recently, the government has also issued students should not be hurt by a teacher. That might be the case. The same reflects to the parents also.
I agree that parental responsibilities internationally is changed, but India did not ratify that agreement.
Okay.
Indian culture is different. So now coming back, anyone who said no, anyone who wants to say no, they cannot be a tort.
No, sir.
Who will agree?
No, sir. No, sir.
Why?
It is
No,
the
you
duty
say
of the
easy, but
father, sir.
why?
It is the responsibility and duty of the father towards his son, sir.
I remember I explained.
There is no damage, sir.
Legal validity of social values,
Yes, sir.
morals in house. father is taking care of the son, and can there be any kind of thought,
Head
legal
of the
value
family
relations,
and responsible
culture,
person, sir.
Indian culture?
Moral obligation, sir.
Yeah, will come in way. Probably it cannot be enforced in India because we don't have. See, internationally, I agree, madam. Probably the parental responsibilities are changing. Uh, until exclusively up to the age of 14, probably they are well protected internationally, but within India did not ratify such cases. Harm national level, but
Okay, sir.
within India, probably the children are within the framework. They are controlled by parents. So up to 21 years probably may not. After majority or 18 or 21, probably I agree with you. Yes, but our Indian culture also matters because in India probably there can be a tort law only after 18, 18 years or 20 majority age, and that and the harm, what kind of harm also needs to be clearly explained. So this is
And
how.
moreover, they have the multi-parent system. Sir.
Sorry, multi.
They have the multi
Shravan, yes.
system actually because most of the Western countries. That's the reason they might have put this the violence clause and all.
Yeah, now see, even state recognizes the rights of the children more than the parents. Foster, probably in India it is not so developed that you have a kind of foster care as you have it in foreign countries where, see, if the child is displaced from the family because of institution of family, the sociology, the social aspect of the family, we cannot think because tomorrow who is going to take care of the child? If there is some thoughts, the father will kick him out, father will send him out. Huh? So, the institution of the family, the sociology, the concept of the family institution is very strong. Probably, if you look at that concept of the institution, society is more stronger. The family ties, the care is very the bondage is very strong, so hence the social value, the social concepts of the family will take over the prohibition, that is restriction part of the state. So state cannot clearly give any sanctions, any kind of that is, even courts probably will not be inclined towards such, encouraged towards such thoughts. Am I okay? Clear?
Yes, sir.
Oh, okay. So you are very much clear where you have a law of thoughts and where you have where you cannot bring any kind of legal action. Okay. So,
Sir, one question here.
Any gesture for to excite. See, certain times it happens that we give gestures to children. Suddenly they cry. This is also kind of social value. So probably, yeah. And but if you are trying to give the same gesture to an adult, yeah,
Doubt, if it is for,
more worrying gestures.
excuse me, sir.
Yes, ma'am.
That is for children. The social values for children. What you are told right now,
Okay.
and that and the same. If the same happens in family with the elder people, then what is that? Is that also social value or
Bit more clear, ma'am. See, you need to elaborate. Elder family in the sense how,
elder family in the sense brothers?
Just check.
Elders in the family in the sense brothers like beating something, etc.
brothers beating probably what age?
At about 20.
About 20, probably not. After 12, after 12 years, probably up to 12 years, they have full protection from the state. Children up to the age of 12 years, they have exclusive protection from the state. That protection levels slightly decreases after 12 years. So it is a balance. What kind of act or what kind of omission? See, incitement. If someone is encouraging do is also a kind of assault. Inside, they are trying to induce to. They are trying to introduce you to some kind of nonsense. Probably it is also a kind of an assault.
Okay, sir. Thank you.
So it happens. So three elements must be established in order to establish the tortious assault. The danger, the create physical contact. So whatever some kind of, if there is any kind of physical contact that needs to be established, some reasonable danger of a state, some kind of reasonable danger the intention is to be understood. So what kind of interference is causing to you needs to be established. So there are three elements in assault: the physical contact, the reasonable apprehension, and the interference with intention. What is the clear intention needs to be clearly established.
Sir, what the third one, sir? Third one.
Interference with intention. Wantedly they are doing. If you come across some words like disobeying is intentional word. The word intention, intentionally causing some kind of of harmful or unwanted contact. Some kind of harm or unwanted contact. So what is the general intent means the defendant knew that some substantial certainty that the action would put someone in danger of a harmful or unwanted contact. So what is substantive certainty, substantial certainty. See, there is some kind of law, probably to assault. See, everyone has got a freedom to enjoy, but that freedom should not harm other. So, substantial certainty. Substantial is some kind of restriction put by the state that you will not cause loss to the people. So, probably assault is a public wrong, which is clearly defined under the IPC, and when they are put to certain kind of fear of a harmful or unwanted contact. See, if you are putting any individual that some kind of harmfulness, and so threaten, some kind of threaten. So I am fear that tomorrow someone is going to cause some kind of harm or some kind of unwanted contact. So someone you call them up, say, threaten them, stating tomorrow you do this, I will see what you. Tomorrow you come to court and give witness, then we will see your end. You will not go tomorrow. If you are going on the same path, probably some kind of that kind of acid attacks are also a kind of an example. Probably, maybe some threat, some fear, some danger of harmfulness. Okay.
Sir, one question. In case of criminal offense, let's say if somebody is suspected, can that suspect be arrested even though we may not have direct evidence at that point in time?
Or a kind of contact, unwanted contact. So they have never expected such things to happen. So it is a kind of sense of personal dignity. See, every person will have a dignity. Every person will have.
Voice is not coming, sir.
Probably Principal Ma'am is calling. I have to go. Anyone? Any question? Did you understand the concept? What is assault?
Yes, sir.
Okay. You have any questions? Any examples? Anyone?
Yeah, there is a question on the criminal offense, sir.
Criminal offense, yes.
So, in case of any criminal offense, let's say we suspect somebody, and can that suspect be arrested even though we may not have the direct evidence at that point in time?
Criminal law beyond reasonable doubt. Criminal law is very clear. See,
so can we arrest the suspect?
No. It is cognizable non because it's a long process again. See what kind of offense, probably cognizable, non-cognizable. It all depends on many aspects. Single point you cannot decide criminal case.
Okay.
See, it is 3 years, more than 3 years, up to 7 years. Then notice nowadays there are more guidelines. If he's trying to run away, it is again discretion of the police. If it is cognizable, it is situation to situation, it varies.
Okay, understand. Yeah.
Okay, so it goes about. We have to be more practical. So situation while police power.
Understand. Yeah, thank you.
So. Yes.
I have one example where A threatens B with an unloaded pistol, which B knows that it is an unloaded one. It is not assault.
Yeah. Yes, madam. Unloaded pistol is trying to
No, B
cause
knows that it is
some
an
kind of
unloaded
fear.
one.
The other opponent doesn't know, right?
Opponent knows that it is one. It is an unloaded one.
Okay.
So is
Then-
it assault or not, sir?
See, if he doesn't know, probably it can be an assault. But when he knows that that device cannot cause any harm, what is the harm? What is the loss? What is that he is causing any fear? He is causing any incitement?
No, sir, nothing as such.
Then probably it cannot. It can see reasonableness. Probably I cannot find any reason to be frightened.
Okay, so it's not assault.
Of causing fear. See, if it is a loaded pistol, probably yes. There is an apprehension, there is an cause of danger, but without unloaded pistol, but Arms Act will clearly restrict holding the possession of pistol. It is a public wrong, but probably not when the opponent does, when the opponent whom is trying to cause fear. If he knows, probably he should not. There cannot be a tort. Okay.
Yes, sir. Thank you.
But if any harm is there, yes, you have to look at the circumstance and harm. Then see, even the aspects of torts, you also have nervous shock.
Sir, I think using of gun itself, loaded or unloaded, I think there is a reason to assault.
Yeah, there has to be a reasonable cause. Okay then. Probably we will take. Meet in the next class.
Thank you, sir.
Okay.